how should these national security exemptions will be governed to prevent this privacy from overreaching?
Yeah, so again, that's in the DPDP Act. There are some exemptions, but I think and there is a lot of discussion around that as to who can take those exemptions, who cannot, and all these kind of things. So basically, Section 17 2A is essentially in the DPDP Act. That is the one that is empowering central government to exempt certain state instruments from most of the obligations of the Act, where the processing relates to, as you might expect, sovereignty, integrity, security of the country, public order, prevention of cognizable offenses, and so on and so forth. So, in fact, prevention of cognizable offenses itself is a huge range of law enforcement activity in its own right. And then there's a Rule 23 of the DPDP Act goes further. It grants the central government authority to demand personal data from any organization for the 7th schedule purposes, which again relates to national security, public order, etc., etc. This has drawn some criticism from civil society as it is felt it creates a government data requisition power with no independent check at the point of exercise. Section 17.4 adds a second exemption, that is processing for research, archiving, and statistics is also exempted. Now, in isolation, this sounds reasonable, but some people believe it creates a secondary channel or a backdoor channel through which security adjacent data processing could be routed to avoid obligations that would otherwise apply. So that remains to be seen. So if you look at how should it be governed, as you asked, I think basically there are about 3 or 4 structural accountability things that one should be careful about. One is that there is no judicial oversight. The DPDP Act contains no mandatory judicial review mechanism, either before a security exemption is invoked, which is ex ante, or after, which is ex post. So this is something that might be looked at again. The Data Protection Board may even look at it, even though it has no jurisdiction, as far as I understand it, over anybody who has taken the exemption, but yet it may look at it. Some other countries have also dabbled in this, and they're trying to create something. So that's one thing to keep in mind. There is also no retention limit. So data collected under a security exemption has no statutory maximum retention limit. So there's no mandatory review at which a designated authority must determine whether the security justification still holds, et cetera, et cetera. There is also no downstream harm accountability. So the Act does not address what happens when data collected under exemptions is subsequently misused or leaked or anything. And there's no designated authority to receive breach reports involving exempted data. For normal data, the breach report has to go to the principal as well as the Data Protection Board. So here, that is also not there. So these are some, you might want, some people are calling it gaps in the DPDP Act, but maybe some things might get more fine-tuned as we go along. But what a governance architecture might look like is we might land up having an independent National Data Security Review Board, just like a Data Protection Board. Maybe, and this is just some thoughts, it's not that this is being planned or anything. It can be constituted with some retired Supreme Court or High Court judges, privacy experts, etc. So any notification of Section 17(2)A exemption invocation, they will receive, this board, within 30 days of that. And the board's role can be not to second guess any security decisions, but to verify that the exemption is within the authorized scope, that a retention limit has been specified, and so on and so forth. So time-bound processing authorizations should replace some open-ended exemptions. And breach accountability should not disappear just because the processing is exempted. See, in 2021, when we were having the pandemic, as many of you will know, there was a breach from the government COVID portal. And that demonstrated the real world consequences of accountability vacuums that kind of exist, because there was no requirement to even notify this at that point to the people, So security exemption should not mean breach immunity. So there are some frameworks available outside India also. UK's IPA framework is there. And European court also has some framework, and even the Five Eyes intelligence agreement that's been in the news a lot, even they have some data handling protocols across their jurisdictions. So I would summarize this and say, okay, national security exemptions are constitutionally necessary, but no serious privacy framework will deny the state the ability to protect its citizens from genuine security threats. So the question is not whether exemptions should exist. They obviously should, but they have to be governed by some framework that makes them accountable, proportional, time limited, and subject to independent review. Does this exist in the DPDP Act today? No, but I think these things will get updated to reflect these things.